mom twin. In my daytime job, I'm the Director for Plan Giving and Major Gifts at UMRC Foundation, which is short for United Methodist Retirement Communities Foundation. In my spare time, I serve as the secretary on the board of the Plan Giving Roundtable. Today, it is my distinct honor and pleasure to introduce our speaker, Mr. Tom Barrett. Is it okay if I say Tom? That's right. Senior Advanced Markets Director for MetLife Premier Client Group. Tom is a member of the Estate and Business Planning Attorneys in MetLife's Advanced Markets Group. He and the entire Advanced Markets team provide sophisticated estate, business and retirement planning case design assistance to the top tier producers and the agencies in the MetLife enterprise. In addition to this case design work for affluent clients and small business owners, Tom is also actively engaged in all aspects of estate and business planning training for the MetLife field force. His duties include development of marketing and sales material in support of the use of life insurance in financial, estate, and business planning. Tom graduated from the University of Dallas with a degree in English and a minor in international studies. He received his law degree from the Washington College of Law and the American University in Washington, D.C. He subsequently received his LLM in taxation from the Washington University School of Law in St. Louis. He worked in private practice in Washington, D.C. when he joined Gen America, which was acquired by MetLife in 2000. Tom is a member of the Maryland Bar Association. Please join me in welcoming Mr. Tom Barrett.
Wow, that was impressive. How much of it was true?
You tell me.
Jackie knows it's not all true. It's going to be spot the lie. I am an attorney after all.
Yes.
Are any of my brethren here? All right. Did any of you go to a law school that's better than my law school? And if so, can you do this presentation? No? One of my good friends went to Georgetown, and every time someone finds out that we're lawyers and we're going out, they say, oh, where'd you go to law school? And both say Washington, D.C. And invariably, the next thing that someone says is, oh, Georgetown? Ben smiles, and then I have to shake my head and say no, like I'm apologizing. But my therapist says I'm getting over it. So we're here today to talk about estate planning, specifically techniques related to a low interest rate environment. But I wanted to gauge how much experience everyone has with estate planning. Are any of you practicing in that area, or is it more from the charitable giving donor side, or the attorneys in the room? Are you estate planners by your okay? So just one. So if I have any or if you have any questions, just jump in. Jackie's heard me before. You know that I have a really dry voice, and I told the video guy that I was going to put him to sleep, and I'll put you to sleep if you don't ask questions. So we can make it interactive. And if we get off the rails, then we'll try and bring it back. I'm from St. Louis. They flew me in. They do that because anyone who's out of town with a briefcase and a suit is an expert. But I do have some experience with this charitable giving stuff and with estate planning generally. So that's why they asked me to talk. Any preliminary questions? Shall we jump in? All right, jump in. No more fun games. So I come at this because of my experience, not just as an attorney, but specifically from the life insurance financial services perspective. So if I slide into insurance speak, try and catch me. We find that a lot of techniques can be married with insurance, but today's session is not about that. So if you see me trying to give you a sales pitch, let me know. All right? You will. Okay. You don't want to Could give us a bad name. All right. So, the estate planning landscape. These days, estate planning only affects a very small number of people. And when I say, estate tax planning only affects a very small number of people. Now, I'll go even further. Federal estate tax planning only affects a very small number of people. And so when we talk about estate planning generally, with clients, for example, we're not just talking about techniques for people who have more than $11 million. Today's exemption amount is $5.3 million per person. If we're talking about estate planning to someone, typically we're talking about things like wills and powers of attorney and medical directives and those things that we all need. It's not just about planning for people in the top half of the top 1%. But when it comes to those people, the landscape has changed dramatically since ATRA, as the estate tax exemptions have risen and the estate tax rate amount had dropped from 55% down to 40%. Nevertheless, some people, for whatever reason, still feel that handing over 40% of their net worth above $11 million is too much. And fortunately for those of us who work in the plan giving community, the estate tax is still there in the sense that it's driving the herd towards gifts that they might not otherwise make. But for the others, 40% is a bit of a pill to swallow. And so we have techniques to help them maximize the use of their exemptions and to limit the amount of their estate when they die. And so I'm going to presume that everyone knows certain basics about estate planning. But again, raise your hand, because I don't want this to be a monologue. All right. So, interestingly, today's estate planning has as much to do with income tax planning as it does with the pure federal estate tax. So, as you can see, the highest ordinary bracket these days is 39.6, but with the Medicare, with the Affordable Care Act supplements, you get an extra 0.9 on that. On the capital gains side, we go as high as 20%, but there's also the 3.8% surtax that potentially applies to our high net worth clients. And so, if I were doing a different version of this presentation, we might investigate a little bit the balance between helping save estate taxes, which I think is a straightforward exercise, versus the more complicated issue of balancing an estate's income tax or the beneficiary's potential income tax versus savings on the estate tax side. So for example, if Jackie and I were married, number one, we'd be really happy, right? You know that. But number two, we probably have a lot of money, right? That's for sure. We both make a lot of money. We might want to give our money away. It would be a straightforward exercise to give our money to our kids or to give our appreciated assets to our children. But having them inherit appreciated assets via gift might not be the best thing from their income tax point of view. So if Jackie and I didn't have $11 million, it might make more sense for us to keep the assets or engage in estate planning that involves a step up in basis on the income tax side. So a different version of this, like I said, would involve planning on an asset by asset basis with respect to the income tax. And let's say that's for our clients who are not necessarily exposed to the federal estate tax, or maybe only for those clients who are exposed to a small amount of state estate tax. For them, this income tax component is more important. We point out that in California, if you add California estate tax or income tax on top of the 39.6%, it's in fact higher than the federal estate tax. California has no state estate tax. So for people there, planning to avoid the high income tax is almost as important as the estate tax. And I think Michigan has an estate tax? No. Or did it got repealed as part of the? Yeah. I understand you have some other interesting taxes, though. before, I think this morning, I thought that Inkster was an app you can use to share books. Is that not true? That's not what it is?
No.
And there's a tax, right?
They're trying to tax it.
Okay. That's the closest thing to a tax joke, right?
Right.
But not there. All right. So let's give an example. The indexing of the high exemption, the $5.43 million exemption, means that most estates are going to be sheltered. So if you project forward, and that amount is increasing the cost of living adjustment. So if you project that forward, in this case we did it 20 years, a married couple, and that is to say married in the eyes of the federal government. So if they're validly married via state, the federal government will recognize that. The couple could transfer, we estimate, $17 million of net worth without federal estate tax. So that again underlines the idea that for estate planning, what we're going to call estate tax planning in the future might get more and more into income tax planning. So generally, for most of our clients, it's going to be more important to plan for an income tax basis step up. So for example, Jackie and I holding on to one of our beachfront properties, dying with it so that it gets a step up in basis. And instead of giving it away, which we might have done in 1996 or what have you. So, addressing the interest rates. We'll get to the substantive stuff soon. I got to work through all my material. This is a chart of the midterm versus long-term applicable federal rates. I picked out just the January and July because it was getting onerous to do all of them. But these are two of the most important rates that we talk about when we talk about planning in an low interest rate environment. And you can see that, interestingly, the midterm rate, which I had assumed would always be lower than the long-term rate, is not always lower than the long-term rate because it fluctuates more rapidly than the long-term rate. A dramatic change in economic circumstances can cause the rate to be adjusted at a rate such that it actually surpasses the long-term rate. But you can see that we're in an era of historically low interest rates, both on the long-term side and the midterm side, during my whole life. Over the course of my whole life, this is the lowest it's ever been. It's not funny. All right. So, does anyone know what the midterm rate is for this month? I'm curious. No, neither do I. I was just asking. If there were only some way that somebody could look it up.
We were told to turn our.
Excellent, excellent. So the long-term rate is going to be important because a lot of the estate planning techniques that we do are intended to pass wealth, not the wealth that or the asset value as it is today, but the growth between when we give it away or when we transfer it to the future growth. So these techniques will have long-term horizons, and the long-term rate is going to be applicable to many of those. The midterm rate is important because the other estate planning techniques related to CRATs and CLATs and CRUTs all depend on that. Anyone know what rate that is? I'm sure we've heard it a zillion times. The rate that GRATs and CLATs and CRUTs are used? 75-20. Thank you. The first response. I should give you my business card with the mobile number on it. You're not going to want it. So the 75-20 rate is simply derived from the midterm rate. So when we do GRATs and CRUTs and CLATs, we're just basically using the midterm rate plus 20%. So the interesting thing about that is when I charted this, we saw before that the midterm rate is generally lower than the long-term rate. So when we're doing calculations, that we need to keep that in mind. But the 75-20 rate for most of our charitable estate planning techniques actually bumps higher. And so when I try and decide whether it might make more sense to do a GRAT versus an installment sale, one of the things I'm going to look at is, besides the time horizon that the clients have in mind and the other soft issues, when I'm looking at the numbers, I'm going to just try and look and see where the rates are relative to each other, because that might give us an idea of which technique, at least at first blush, is going to be the best for them. Questions so far? All right. Questions from the back? No? Good? All right. So, the most common charitable-related, interest-sensitive technique that I see is the charitable remainder annuity trust. And for those of you, is everybody familiar with those? Show of hands. Who's awake? All right. So, cutting to the chase, because it uses the 75-20 rate, it's interest rate sensitive. In other words, the way that we calculate the present value or the way that we calculate the annuity, both depending on the term, of course, will be affected by the 75-20. And unlike the GRAT, which we'll take a look at, this one requires a 10% remainder to charity. So let's take an example and try and figure out what's better for the CRAT, or who's going to benefit from a low interest rate environment. When the IRS came up with these rules, they said that the 75-20 rate is, in effect, the rate that we're going to assume that these assets are going to grow at. We're going to assume that they're going to grow at that rate. So when we value the annuity and we value the remainder, we're going to use that rate in our calculations. It has no bearing on reality. It could be invested wisely or poorly. It could grow at 12% or at minus 12%, minus 12 if I'm picking, judging by my 401k. But however it grows doesn't matter. What matters is the snapshot when it was created. And here we have two CRATs. They're going to be identical in most ways. The difference being that one was created when the 75-20 rate was low, like it is now, 2.2, and the other one at 4, like it was maybe 5 or 6 years ago. Each one is going to use a 10-year term, and a $100,000 contribution, and an 8% payout. So the interesting thing here is that if you fix the remainder amount, like you're targeting a specific charitable deduction amount, in our example here, the $55,000, a lower 75-20 rate results in a lower payout to the annuitant. So if your client comes to you and says, I need a $55,000 or 55% charitable deduction in a low interest rate environment, you can target that, but it means that the annuity coming out is going to be lower. So here's the $55,000 question. Is that good or bad? You want to venture a guess? It's excellent. The lawyer answer. It depends. On the one hand, I'm going to charge you in 6-minute intervals, and on the other hand, I'm going to tell you 2 different answers so I get paid twice. I joke about that, but that's to illustrate an important point. It depends. Who's your client? What's the overall objective? So what's the advantage of, or why would it be better for a client to have a higher 75-20 rate? It's a bigger payout. That means that your client is interested in retaining larger income. So for example, this might be appropriate for a client who has decided they need a certain amount of income for the rest of their life or for the next 20 years or what have you. And they say, I want a bigger payout, or it would be more advantageous for me to have a bigger payout. If that's the perspective we're looking from, the client's perspective, and income is important, then higher interest rates are better. If, on the other hand, your client is a charity, maybe CRAT number 1 is better because the client is going to get less of a payout, a smaller payout, let's say, of $5,000. And what does that mean? What does that mean for the charity in practical terms in our 10-year example here? Well, that means that if I invest $100,000 and I have to pay someone out 5 instead of 5.5, what's likely to happen with a pile of money? Bigger pile of money. Bigger pile of money. You must be married, right? He's not my wife. I'm interested in a bigger pile of money, honey. Yes, we should get married, right? We'd work out well. Yes.
Would the age of the annuitant be a factor in your decision?
The age of the annuitant can be a factor in terms of deciding whether a 10-year term makes sense. So for example, we'll have if you have a client who's old enough, then you can do a CRAT for their life. And it will work in the sense that you can model one within the parameters that the IRS gives you. If you get someone who's very young, you can't model it for life in some cases because their life expectancy is so long that the charity's going to wait, and the annuity has to be too small for the deal to work.
In the case of my audience,
Mm-hmm.
it's like life expectancy of 5 years.
Yeah.
So old.
Right, so this is a very simple one. You can model one that's shorter, life expectancy, or 10 years, whichever comes first. You can do one whichever comes later. So someone says, I want to go 10 years, but if I die, I want it to go to my spouse. Or if she dies also, then I want it to go to the kids. I'll name all the beneficiaries, but it'll go for 10 years. We look at the client's overall financial picture and say, how long do they need the money realistically? Some people do this because they want the upfront deduction, but it's really only appropriate for clients who need the money also. In our example, our $5,000 a year. If they didn't need the money, I would counsel them maybe just to do a direct gift. It's a lot less complicated. But maybe instead of a direct gift of $100,000, maybe we'll do a direct gift of $60,000. And they'll keep the 40 if they need the money. So, just depends. Yes, sir.
I've seen people that are interested in the CRAP or our charitable remainder trust, and have older parents
Mm-hmm.
that are just supporting, they're looking for a way to maybe not issue securities.
Okay.
And they put it in their charitable remainder trust and get it
Right.
for a few years. They want to be able to provide their parents some money.
Right, so they're going to keep the income stream while they have the support obligation, and then give it away.
They actually give it away.
Oh, they give it to their parents. Okay, yeah, that's certainly possible. I've seen it where people give it away to their kids, but that's a good spin as well. And so for gift tax purposes, we have to do the same valuation. The tricky part is giving away after you've received the income yourself for a few years, and valuing the future income, the income stream in year 7, for example, or year 5. If they give it away right at the beginning, it's easy enough to calculate what the gift amount would be. So in this example, it would be $44,000 and change, a gift back to their parents. So far, any other questions? So, no, it happens. I'm totally, I'm fine with it. I'm fine with it. I'm getting my stipend either way. So, is a lower interest rate environment for CRATs? Let's pose the question in a slightly different way. So this example, consider 2 CRATs. Again, they're going to have identical terms, 2.2 and 4%, $100,000 contribution. But this time I fixed the payout percentage. So they're both going to generate $8,000 a year for our annuitant, or our donor, depending on how you want to label it. You can see that the lower interest rate derives a lower charitable remainder percentage. So, is the lower interest rate good or bad for CRATs? And as we've discovered, it depends. I get people who call, when I say people, financial advisors and their clients call me and they say, I need a remainder value. I want a deduction of 50%, or I want a deduction of 34%. Well, for those clients, the interest rate environment that we're in means that they're going to have to take an even smaller annuity. They're going to have to shrink the amount that they're taking out of the deal in order to get that target charitable deduction higher. I would say that's a bit backwards. When I think of charitable remainder trust, I think about what the client's personal financial or their parents' financial need is, and use that to drive the calculation, and let the remainder be what it may. Is that the experience of people in the group, or Or do you get people who are looking, every now and then you get somebody who just wants 50% charitable deduction, and that's fine. But in this interest rate environment, it's a lot harder to drive it that way. We good on crats? I have to be careful. I went up to Detroit looking for crack. I will get in trouble. Yeah. So, as we've discovered, if the goal is to maximize income tax and tax deduction, lower interest rate bad, higher interest rate better. However, it allows you to take a smaller annuity. So if you're genuinely charitably driven, it means that the payout, because the payout to our donor is smaller, it's more likely that more money will pass to charity. It's all a matter of perspective. It's funny that in my business, in the for-profit side, what we call truly charitable-oriented grantors, as opposed to those who are faking it for tax purposes. So, unit trust. A charitable remainder unit trust, I don't see as many of these as I used to, but they're still quite popular. The CRUT, same as the CRAT, there's going to be an income interest for life, or for a period up to life, except that the measure is going to be a percent each year of the value of the CRUT instead of a fixed payout annuity. So in our example, 6%. But the rules relating to it are the same. And so as you might expect, the 75-20 rate, not as you might not expect though, because the payment amount is fixed at 6%, whether the rate goes up or down has very little effect on what the charitable remainder amount is. It's almost as if, because the grantor and the charity are in effect both earning, you might say, a proportionate piece of the pie instead of a fixed amount, that the rate can go up or down, but they're still going to get their same proportionate amount. So this is why the calculation ends up very similar regardless of rate. So here we modeled a 15-year CRUT with a payout of 6%, and the rate of charitable value or present value is about 40% in both cases. So CRUT planning hasn't been affected as much. What situations might be more appropriate for a CRUT as opposed to a CRAT?
Somebody who wants to know exactly how much they'll get.
So in a CRAT, you would want to get, I want 50,000 or whatever it was in the last slide.
Where
Exactly. A risk taker, a wild person, somebody on the edge, right?
Yeah, that's right.
Might want a unit trust, right? Because we're willing to participate in gains. So to put that in concrete terms, you might have someone who gives an asset that's expected to appreciate rapidly. So not at the 4% or 2.2% that our IRS assumes, but if I contribute something like stock pre-IPO or just or maybe small business stock that or real estate investment, like if you have an LLC and you give away 20% of it before the deal closes, but when the deal closes it's going to jack up in value 5 times, our grantor might want to retain a piece of the higher income or the potential to receive higher income in the future. So in this case, the CRUT is going to be the better option. Instead of being limited to $5,000 a year or $5,500, what have you, they're going to get 6% of whatever the total value is. If our $100,000 contribution goes to $400,000, now our grantor is getting 6% of a much bigger pie, if you will. So we're looking for clients who are interested in the potential future increase in their income. For everybody else, most of the clients we get, they're looking for a specific income number, and that's why we recommend the CRAT to their attorney first. Sir?
What are you seeing as to the principal amount that you need for it makes sense to set up a remainder trust?
So that depends on the administrative cost and the attorney's fees. So I don't mean to smile when I say attorney's fees. It's been hammered into me.
Yeah, I'm a lawyer. Lawyers kids have fees.
That's right. They just don't need the Tiffany bracelet. I'm trying to. So I think if you have a CRT that's sponsored by, if you will, the charity itself, they're providing the form, they're gonna do the administration, then the cost is low, and that number could be 40,000, 20,000. You get very low with that. Most of the clients that we look at, because by definition they have estate planning concerns, they're dealing in numbers at least this big. I mean, I think this is more like the starting point. I try and steer them towards charitable gift annuities and things with a more efficient administrative cost if the numbers get much lower than this. But if an attorney is willing to do the work and the client's going to be their own trustee and investment advisor for the fund, and there's not going to be any drag, you could go very low. But almost by definition, the people that we work with who have federal estate tax problems are looking at more zeros anyway. So, but let's say $50,000 if I have to pick a number. Anybody else have? I'm just some guy from St. Louis. Anybody else have experience?
Would you want to do a unit trust maybe? Like I'm guessing people would not want to do a unit trust because it's probably more set for long term. Is that correct?
Well, you could do a unit trust for 3 years or 4 years, but you have to be willing to accept the risk that your payout's going to get smaller. For example, if you invested it, if at the time that you put it in Tesla stock, you put Tesla stock in it, it's 255 or whatever the number is today, that stock oscillates like crazy. Next year, when the trust is being valued and your interest is being determined, that stock could be at 150, and all of a sudden that income interest is cut down by 40% or what have you. So it's that volatility risk increases as the term of the trust gets longer. So to your point, if somebody's really nervous about it, they would probably shorten the term. And so the problem is when you shorten the term, you're not getting as much money out in total, so there's kind of a natural balance.
Of course, some of the charitable remainder, they have a issue with fiduciaries selection of retaining Tesla stock.
Well, that's true. That's true. I've been speaking just about the tax element, but there's a fiduciary reasonable investor standard or even higher standard, which I'm sure you could learn about from our friends at Northern Trust. So leaving it all in Tesla stock that fluctuates might not be the prudent thing to do, right? So I find that a lot of crats, they put in the unappreciated real estate, or they put in that single block of stock, and one of the ancillary benefits is the diversification. So they're going to sell that stock. The trustee is going to sell that stock because there was no prearrangement to sell it. The trustee is going to sell that stock for that diversification reason, not long after it's contributed. So, anybody else? Sir.
I think a lot of people like cruts because they can make additional contributions to it.
Exactly.
They don't pay an attorney fee and
Exactly.
new document.
That's a very important point. The CRAT is a fixed technique where the CRUT you can keep modeling. So if you did a 15-year CRUT and you give next year, you're putting money in a 14-year, et cetera. So that's a very good point.
Okay, back to my audience. They know the life expectancy is very small.
Mhm.
So all they want is enough payout to pay for the expenses of the home. And they want the remainder to be as large as possible to the charity.
Mhm.
So would this be like a 3-year, would this be a good one?
You could do it for 3 years. We would look at them, if let's say $100,000 is the amount of money that is in play, we might ask them to look at giving away $80,000 or what have you outright today, and just keeping the 20 for their own financial needs, just amortize that over their life expectancy, as opposed to doing the CRUT with its costs. But you could do one for 3 years. I do think that they might be longer term, might be more appropriate. But you could do it. I run the numbers both ways every time just to make sure.
My other question is, could you comment on any variation that this might have
Sure. So the NICRUT refers to, is everybody familiar, or do you want me to go? All right. The NICRUT is a net income makeup CRUT, or net income CRUT. And basically, the trust, instead of providing 6% no matter what every year, it might be limited also by the amount of actual income earned by the trust. So, for example, if our trust here, with a 6% payout and a $100,000 contribution, let's say that it's invested and it only earns 1% that year, but it owes 6% to the grantor, a NICRUT paragraph in that trust would say that the trustee doesn't have to pay out $6,000, only has to pay out $1,000. So it's the lesser of $6,000 or whatever the income is. And then to follow up, the NIMCRUT is the next logical version of that says that in years where you were only paying 1% or 2% less than the 6% that the grantor was supposed to get, you make that up in future years when there's higher income. So that's a good technique if you're doing something like unimproved real estate, or something that's, if the clients don't need the income this year, but they're going to need it in a future year. So sometimes we see somebody who's age 60, they're still working, they put the CRUT in place because they want the income tax deduction while they're making buckets of money, right? They're making buckets of money, but we want to turn that income spigot on after they're retired when their tax bracket's lower. So you might invest it in a way that generates less income while they're working and more income in the future, and then it's made up in in my example, like years 65 to 70 or 65 to 75. Yeah. All right, the CLAT. The CLAT is the flip side. I'm sure we've all experienced it, but just to review, same as the CRAT, except the charity's getting the income interest and the remainder is typically going to the grantor's heirs. So they've just changed places. So the calculations are the same in terms of the IRS annuity tables and using the 75/20 rate. There are a few other important differences. The CLAT was famously unused by Jackie Kennedy Onassis in her will. Sometimes you read about in the literature that she's the first one to use it or whatever. That's not true. But her will did stipulate the potential to use a CLAT. Their executor ended up, for whatever reason, not using it or not funding it. But famously, she was the first one, the first famous person to use it. The trick with the CLAT is that it can be zeroed out so that the amount of the present value going to the family, let's say 20 years after the trust is created, that amount can be reduced to zero. So we see this almost exclusively in cases where ultra-high net worth individuals have fully used their exemption amount, and they're looking for techniques to get money to their kids without paying gift tax or estate tax. And because the charitable lead trust can be valued at zero in terms of its gift tax value to the family, it's the last level of estate planning for many individuals. I say it's the last level because most of them, again, are motivated at getting more money to the family. If you have a truly charitably inclined grantor, the CLAT has value also, but typically they're looking at the other side, at the CRUT, CRAT, at least in my experience. So, yeah, this last sentence is important. Informal comments by IRS officials indicate that the IRS is not a fan of zeroed out CLATs. Somebody from our department goes to the Heckling Tax Institute every year, and there are invariably IRS speakers there, and this is where we get this information at the coffee chats after the plenary sessions. And so we heard directly from one of the IRS that they're not a fan of this. So we'll see what happens with zeroed out GRATs and zeroed out CLATs soon. Back to our main question, how do the interest rate fluctuations affect our CLAT? So compared to the CRAT, the change in 75/20 rate dramatically affects the value of the remainder interest. So in our example here, the change from a 2.2% to a 4.2% results in a quite dramatic, more than 160%, I'd say, increase in the value of the remainder interest gift. So, let's say that our typical CLAC prospect is going to be ultra high net worth. They've used all their exemptions. They're trying to get money to their kids, or they're more likely their grandchildren, because we know what Timmy's like. We don't like him, but we love our grandchildren. In this case, in order to zero out a CLAT for this hypothetical client, the low interest rate environment is much better for getting that remainder value down to zero. In other words, the value that we have to, the value that we're targeting, trying to get it down to zero, will be much easier in terms of the annuity paid out to the charity in a low interest rate environment. So again, is it good or is it bad? If I'm the charity, the low interest rate means that my grantor was able to get a lower gift tax value, and so that might actually be better for our charity because the annuity amount coming out was smaller. And if we're the client, certainly the low interest rate environment in terms of getting money to the kids is much better. So wrapping that all in a bow, right now our low interest rate environment is fantastic for clients who are trying to get small present value amounts to their kids. Has anybody had experience with CLATs? Anybody had one implemented? Was it prior to the market taking the header?
A couple of them were, some of them more recent.
Yeah. And did they fall in the ultra high net worth category, or were they doing it?
Yeah, they were looking, our user, they were tax exemption amounts.
Right.
Making additional gifts.
Yeah, 9 out of 10 people, that's what I see. I think you could come across it for somebody with a different goal. Maybe somebody who just wants charity to have money for a period of 15 or 20 years. But because it's so useful for these ultra high net worth clients, that's where I see it the most.
Right.
Sure.
What's the purpose of present value of the gift? What are you trying to achieve?
Sure. We're trying to get money, and again, this is typical of the people that we work with. They're trying to get money to their, let's say, kids or grandkids, but they've used up all their exemption. So if I and my wife die, and we just leave the money to our grandkids, for example, outright, they're going to pay. There's going to be an estate tax and perhaps a generation skipping tax on the money.
Above the
Yeah, to the extent it exceeds our applicable exemptions. If instead we put it in a CLAT, and let's say the CLAT's going to run for 20 years, we can design it so that if I put in $1 million, the charity's going to get an annuity for 20 years, and at the end of 20 years, whatever's left, whatever that amount is grown or shrunk to, will pass gift and estate tax free to the family. So let's say that I have $100 million, I'm way over the exemption amount. I could put $90 million in the trust. Charity is going to get a specified amount every year for, let's say, 20 years, and then whatever's left is going to go to the family. None of that money went to the IRS. So because the value of the trust is determined at the time that I create it or in my will to my estate, the amount that actually passes to my kids we won't know, but the amount for gift and estate purposes can be reduced to zero and determined at the time of my death. So its purpose is to create a zero estate and gift tax mechanism to pass an amount to my family in the future. And the way that it happens is prescribed by the IRS under the CLAT structure.
So essentially you're leveraging time.
Leveraging time. And if you run the numbers on I didn't pick the 20 year by accident. If you pick a CLAT of 20 years, you can base it under today's interest rates. Whatever number you put in is you can zero out for a 20-year trust. In other words, I put in my $1 million, and it's going to run for 20 years. I will expect $1 million more or less to go to my kids or grandkids in 20 years. And meanwhile, the charity's getting 5% every year, whatever the amount is. Again, the actual investment performance will determine how much actually goes to charity, but based on these assumptions, I usually ballpark it at whatever I put in 20 years later, the kids are going to get. So they've lost the use of the money for 20 years. So some people we work with are charitably inclined, and they say, I'm not worried about paying a little bit of estate tax if I can get some more money to charity, or some people don't care about some of the money going to the IRS, but they don't care about charity. So it's really a matter of picking what their underlying core beliefs are in order to determine whether this makes sense and how to design it.
From your experience, who's introducing these concepts to your donors of nonprofits, and how best would gift officers work with advisors to get their donors warmed up to these? This is pretty, it's a lot to take in, even for
Sure.
sophisticated
Sure.
donors.
We work as a team with the advisors of donors or clients. So sometimes the attorney will recommend it, sometimes the CPA will recommend it. Often my group, financial advisors, will recommend it. I've done seminars, for example, sponsored by our local firms, where they invite in clients, and we'll talk about these techniques, because the clients invited are the ones who have expressed some charitable desire on their own. I would say that because of the way that I work and the way that the people with whom I work get paid, we're often the idea factory, and then the attorney and the CPA are executing. I mean, I'm not saying that we're driving and they're just taking orders. To the contrary, but we all are working as a team, and what we offer is the ability to bring up ideas like this. So often we do. Frankly, sometimes you'll hear it just on the golf course. I mean, I don't golf myself, but it's my understanding that wealthy people do, and they hear it from the tennis pro, or not the tennis, from their tennis buddy or their golf buddy, or at the yacht club or whatever. Frankly, that happens a lot too. Bob's got this, I want to investigate this, how can I do it? So as a financial advisor, I help them decide whether that makes sense, and then we bring in the attorney and everybody else. As a gift officer, you can sponsor seminars for clients to introduce them to different ways of giving. I know that's quite common as well. I've done some work in St. Louis where I was brought in by like the Children's Hospital. You know, they'll talk to 100 donors, just throw out some ideas, and some people, you know, it clicks. You know, it makes sense. So you bring the donors, and we'll bring the IRS tax code. So far, so good. Everybody still with me? I knew it was going to be fun. I'm not disappointed. So, sale to an IDIT. Does anybody know what this is? I love the acronyms. So an IDIT is an intentionally defective, irrevocable trust, something near and dear to my heart. The technique looks something like this. I don't have kids, so this is my baby, right? A sale to intentionally defective trust refers to a technique whereby a grantor puts money, where a grantor and a trustee of an irrevocable trust, and let's say this is your garden variety gifting trust for kids and grandkids. The trustee and the grantor agree to an exchange. So it's not a gift, it's an exchange. And I, as the grantor, will sell to the trust $1 million worth of unimproved real estate, and in exchange the trust will pay to me, or will give to me a promissory note. And the promissory note will have certain terms, but typically it's either a 7 to 15-year term in which the trust agrees to pay interest only for the term, and then a balloon payment of principal at the end. And as with other structures, the driving force of this one is appreciation and growth. It's a technique whereby my estate is no longer going to be valued when I die 20 years hence with the value of that real estate, but instead it's going to be the value of that note plus whatever interest I received from the trust and whatever that amount grows to in the future. So this technique is a freeze technique. It's a very popular technique for limiting the amount of value in my estate and pushing that value's growth potential to a box that's not within the reach of the IRS. It's not going to be subject to estate gift or generation skipping tax once the transaction is done. So in the sale to the IDIT, there are a couple of important elements. Let's see if I've included any of them. So the note that's paid by the trust or given by the trust to me can be structured in many different ways, but invariably we see an interest-only example. So here, an interest-only payment example for a 10-year period with a balloon at the end. The note, let's say the note's going to bear interest at whatever the long-term AFR is if the term is more than 9 years. In today's low interest rate environment, that's 2.94%. So to translate that from the French into the English, that means that the trust is going to have to pay interest of $29,400 per year for 10 years and then a balloon note at the end. Or, sorry, $1 million minus 1 comma. Sorry, typo. So in $1 million example, whatever the principal is at the beginning, that's paid out at the end. What's the advantage of this interest only as opposed to amortizing the note? The growth of the assets in the trust. So pick a number between 3 and 10. Integer, please. No irrational numbers. Anyone? For $1? 7. Who said it first? I'm giving the dollar. I'm a little cash poor right now. I just got back from Canada.
Oh, you just got Barrett.
I've only got loonies. Yeah, that's right. That's right. Between that and our honeymoon in Canada, I don't have any US dollars. But. So 7. So the hurdle rate for our trust to invest is 2.9. Let's call it 3%, because that's what it owes me. The trust owes me 3%. Let's call it $30,000 a year. The trust is making 7%. So that means that 4% that the trust does not have to pay out to me is compounding inside the trust. And it's the value of that compounding outside the reach of the estate tax system that drives this technique. That's where the real success is. Now let's say that it grows at 7%, but it's income producing real estate and it's going to triple in value over our 10-year term. Because it's located along the M1 light rail and the values are just going to go crazy when that gets done, right? Yeah, that's a regional humor, isn't it? I heard it was really going to be cool. It's like 3 miles long, like a runway. There is? Oh, really? So we have a guy in St. Louis who owns a very popular neighborhood, basically, and he has imposed a trolley. So all the businesses have to give up their parking spots directly in front of them, in front of their shops, so that the trolley has room to go. And it sounds a bit like that. You know, somebody megalomaniacal. Yeah. Anyway, let's say that our M1 adjacent land that is not owned by Dan Gilbert is going to triple in value because of the success of the light rail system. So not only is it making 7%, but it's going to triple in value. When the term ends after 10 years and the trustee owes me money back, the land is now worth $3 million. The trustee is going to pay me $1 million, and we'll talk about how they get that money. But that means that $2 million of growth, plus that all those little 4% have all compounded in the box for the kids outside the estate tax system. That's the magic of this technique. And in a low interest rate environment, where you're using the midterm rate or the long-term rate, or even the short term, if you do a demand loan, this technique is incredibly efficient. So in 2009, 2010, where we still had depressed values for real estate, I mean really depressed, and super low interest rates, people were doing this as fast as they could. I would have said that Warren Buffett would do this, except we know that he's not doing it, but besides Bill and Warren, everyone under them is doing this.
Who invented it?
A clever attorney, or is that redundant? It's when the estate and gift tax system came into play, there were some court cases that made clear that as long as this is an arm's length transaction, so if I'm the trustee and you're the client, as long as we're doing a deal that represents what unrelated parties would do, the IRS had to capitulate when they lost a few court decisions that it's not a gift by you to the trust, it is an exchange, and therefore it's outside of the gift tax purview.
And you say it's been used since '09.
Oh, it's been used since there was a gift tax. Yeah. So the key to this technique, though, is making sure that everything's above board and arm's length transaction. The IRS really dislikes these, and at some point they're going to try and clamp down. The problem is it's fundamental. It uses fundamental economic and legal principles, and so as long as your rates are high enough, if you're using the market rates, this technique is still pretty solid.
You have to have a pretty good appraisal.
Exactly, and that's where they're getting it. If instead of the $1 million of land, if I sell it for $1 million and it's already worth $2 million, then the IRS is going to get you for as a part gift, part sale. So they're attacking it how they can. Another way they do it is with the down payment. If you're the trustee and I'm the seller, would I really take a note from a trust that owns nothing other than the land I just sold it? Reasonable minds will differ, but 10% is the rule of thumb in the industry that our trustee has to own outside and separate from this transaction in order to give it an economic viability, you might say. So the interest only with balloon is the way that we see it, and you can see if the trust is earning 6% and it owes 2.94% each year, that just the interest figure alone is going to compound 582. So the goal of this transaction is to get this growth amount out of the estate. The $1 million principal is back in the estate because that's what is paid at the end of the balloon term. But in terms of that growth differential, it's very effective. So one way we might see this in the charitable context is to say that we've done this very effective technique with the high growth asset, that M1 adjacent real estate parcel, but I care about charity also. So one way we might approach this is to say the kids are being taken care of here with their 582, and the note that's back in my estate, that's what I've earmarked for charity. It nicely compartmentalizes the value of the asset in my estate to the $1 million in our example. So if I'm informally thinking about handing off the $1 million to charity, but I don't want to give it all away yet, then my estate might say, my will might say, if I die with a promissory note in my estate, I want that to go to charity. And we know the face value of that note is $1 million. So I've seen that done before. That's for people who have a fixed amount, the note value that they want to go to charity, and they're providing for their kids with the trust, so the kids aren't being disinherited. We also see the trust, in conjunction with this, they'll also often buy insurance, so life insurance, so that if the client dies during the term and his estate's not going to receive all of that interest income, if it's going to terminate early, we'll use insurance to provide for the kids. So they're not going to get shortchanged out of this amount if the deal goes south sooner, because he died. If he goes south. I want to touch on this as in the charitable remainder trust. Sometimes clients get a little too wrapped up in the trust and the mechanics, and they think it's really cool. Often, just a direct gift of a property will be much better. In other words, it's a lot easier to do a direct gift to the trust than it is to do this sale technique. So this is a way that we can transfer value to the kids in the future without using exemption. So this might be more appropriate for people who have earmarked their exemption or used it up already. I have some other stuff, but we just have a few minutes left. Does anyone have any questions about anything related to estate planning? Or the prospects of the Cardinals-Tigers World Series? Anyone? No?
I've got to start it.
We got a 5-game streak too. Right. I'm greedy. We're going to lose the Rams. So baseball has to be good. Too quiet. There's got to be some questions. Sir?
Maybe you could go through what you mean by a defective trust.
Sure. Sorry, I had assumed. So a defective trust, the word defective refers to the fact that for estate tax purposes, this is a garden variety, irrevocable trust. I put money in, I shall never get money out. Whatever I put in it is treated as a gift, but it's out of my estate. Let's start with, that's the foundation. So for estate tax purposes, it's effective, it works. But for income tax purposes, even though the money is in, or the assets are in the trust, I, as grantor, will still be taxed for income tax purposes only as if I still owned it. So for example, I put $1 million of income producing property in the trust earns 6%, ordinary income, let's call it. Even though the trustee keeps the money, invests the money, spends the money, whatever the trustee does with it, I get the income tax bill. It's my tax ID number on that trust, as if I still own the property myself. So in my 6% example, $60,000 of income, if I'm in the 33% bracket, God willing, then I'm the one who pays the $20,000 to the IRS, and the trust gets to keep all 60. So it's defective in the sense that it's permeable or doesn't exist, or however you want to, whatever metaphor you want to use, with respect to income taxes. And the magic of the fact that it's defective for income tax purposes means that in our sale example, where I sold my, I shouldn't put it in quotes, I sold my land to the trust, because I'm making a deal with myself. In other words, the trust and I are the same for income tax purposes. I don't recognize any gain when we do this transaction. So in going back to our $1 million property, let's say that I inherited it from my grandfather and I have a zero basis. When I do the sale to the intentionally defective trust, I don't recognize any capital gains on this transaction because the trust is defective for income tax purposes. And I guess that's another reason why the IRS doesn't like it is that, in effect, every year that I pay the income tax that the trust would otherwise pay, it's as if I've made a gift to the trust. In my example, it's like I gave $20,000 to the trust to pay the tax. In terms of burning my estate's shrinking by $20,000. So it's a very effective technique because it burns my estate. The trustee realizes whatever the gross rate of return is, it turns out to be the net rate of return for the trustee, and it doesn't use any income tax, or doesn't use any estate tax or gift tax exemption to do it when it's structured properly. And how it becomes defective and all that, we have a whole other thing about. We've got some great, and you can contact Jackie or me. Our department puts out these rather lengthy treatises on different tax subjects. Like we have one for this. I think it's included in your materials, planning in a low interest rate environment. But we've got one on grantor trusts, how to use them, how to create them, which situations where it'll work and where it might not be the best thing. So, are we? Am I getting the hook?
Yeah.
Okay. Well, I feel like we just touched on a few things, but if you have any questions, I'll be around for about 3 minutes. I will.
I will.
No, I'm gonna stay for for lunch at least. No, I'll be here. I'll be happy to talk to you if you have any questions you didn't want to bring up here. But thank you for your attention. Only 2 people left, and only 2 people fell asleep, and 1 Facebook.
Can we get the slide? Can we get the slide?
The slides should be included in
There
the,
it is. Okay.
yeah. So,
Thank you for your presentation. I hope you all enjoyed what I did. And allow me to congratulate you with a token of appreciation
Okay.
from the council, which is a small gift to charity.
okay, thank you.
Those who complain.
All right, that's right. Thank you.